This is the current federal tax developments for the week of July the 21st, 2025. Current federal tax developments are brought to you by your state society of CPAs. I'm Ed Zollars, and I'm coming to you this week from here in Phoenix. We're going to talk about a few topics this week. We got a couple of conservation easement cases. We'll split them up a little bit here. We'll talk about a first conservation easement case, the Rock Cliff Reserve case, where the issue becomes that there was at least in the eye of the court, a pre-agreed amount that the appraiser would bring in the value of the property or the value of the easement at before the appraiser had done any work whatsoever. We'll talk about why that wasn't a good thing, at least if the court, in the court's view. We're also going to talk about how a taxpayer managed to foul up a portability election. In essence, it's, you shouldn't really treat a 706 filed to elect portability as a throwaway. If it's not done properly, we have a case this week that shows don't do it correctly. In essence, we're not talking about not filing it on time. We're talking about just not completing it correctly. Can cause you to lose the entire portability election. So we'll talk about that case. We're also going to talk about a case of there's good news and bad news for the taxpayer. In the Boechler case, Boechler may sound familiar because that case was the one that made it to the Supreme Court, and where the Supreme Court ruled that the tax court had to consider equitable tolling for taxpayers in certain collection cases. That was the good news for the taxpayer in Boechler. The bad news for taxpayer in Boechler was the tax court considered it and decided that this corporation didn't qualify for the equitable relief. So good news, bad news. We're going to talk about and we're going to then review our second conservation easement case. And this one is interesting mainly because of the fact that the judge got very upset at this one. And there was a very specific warning given directly to this particular taxpayer or the promoter of the easement that was being sold, and the attorneys representing them not only in this case, but in future cases. And we'll talk about that particular interesting bit at the end of that decision. We're also going to talk about the IRS issued Revenue Ruling 2025-15. Important if you are a retirement plan administrator and you have this problem of you've issued a check, you've withheld federal income taxes on the plan distribution, and then the check just doesn't get cashed. And so you eventually void it out and have to then later reissue it when somebody finally comes looking for their check and wants to know what happened. What do you do about the withholding in that case? And how do you report this? That's what this revenue ruling is looking to tell people what to do. And then finally, we're going to have a Fifth Circuit Court of Appeals. They look at a micro captive insurance deduction, but they also, for the first time for the Fifth Circuit, basically give us a ruling about the supervisory approval of penalties and how that will be viewed in the Fifth Circuit. So we'll take a look at that as well. But let's start with our first conservation easement case. This is a review of the Rock Cliff Reserve LLC case. And as I said, and the court views this as a shelter. And unfortunately, the shelter may be a little bit rickety, and the storm that's going to come at it from the tax court in this case is going to, at least unless they get it reversed on appeal, essentially cause the shelter to go away and shelter nothing. So we'll talk about that here. The case is Tax Court Memorandum Decision 2025-73, Rock Cliff Reserve LLC versus Commissioner, and the opinion was released on July the 14th. Now, in this case, the tax court is going to disallow over $62 million of conservation easement deductions and impose a 40% gross valuation misstatement penalty due to them having an unqualified appraisal attached to this return. And basically that it becomes non-qualified, or basically not a qualified appraisal, simply because everything was pre-planned. Essentially, the appraiser and the promoter, or the partner, came to an agreement ahead of time about what the valuation would be, even though the appraiser had never seen anything about any of the properties, right? Hadn't done any work. So that'd be a problem. This involves the substantiation requirements for charitable contribution deductions of conservation easements. This is another one of those things, and we get into that a lot in charitable contributions, where if you don't dot the I's and cross the T's properly, your deduction goes to zero. Okay, basic issue here. And it does highlight the IRS and tax court's willingness to impose stringent penalties. In fact, in many ways with gross valuation misstatement, it's simply a requirement to do so when claim values dramatically exceed the fair market value. And that's interesting. And by the way, another issue in this case we'll find, even though the court found that because there wasn't a qualified appraisal, the deduction would be zero, it nevertheless, the court still went and came up with a proper value for the easement, and then used that to determine that the unqualified appraisal had grossly overstated, and therefore the return had grossly overstated deduction. It would have been allowed, and imposed the essentially gross valuation misstatement penalty on top of that, and the regular understatement penalty, substantial understatement penalty on the remaining part of the disallowed deduction. So let's talk about the property in this case. It was vacant, unimproved land in Walton County, Georgia. It was there was Rock Cliff, which was 184 acres, and JEB property, which was about 248 acres in total. So there's the land in question. Now, the transaction, Todd Collins, who is a managing partner of Five Rivers Conservation Group, negotiated land acquisitions for property companies, intermediary, and marketed deals to investors. The way this was structured was landowners contributed property to property co's, then sold majority interest to the investment partnership, investcos, right? For example, Rock Cliff property was acquired for $1.1 million. Now, what becomes a problem? The court found there were predetermined easement values. Letters of intent and emails from Mr. Collins estimated the easement values, Rock Cliff at $14.4 million, before the appraiser was formally engaged or began doing any work. So he's promising in selling this property that we are going to, have a $14.4 million conservation easement donation on this property that we acquired for $1.1 million. Now, Mr. Collins marketed these transactions based on that 4.4 to 1 ratio of charitable contribution deduction to investor cost. So the property co's donated conservation easements to Atlantic Coast Conservancy, ACC, and the investor vote on the easement was a foregone conclusion per the court that was intended to mask the pre-planned nature of the transaction. So it was a nice package tax shelter is what the court found effectively. We're signing this, tax shelter in a box, sign here, give us a check, and we will essentially give you a tax deduction that is 4.4 times higher than what you gave us. And you can do the math fairly quickly that assuming we aren't having people in the 10% bracket buy this, that basically the conservation easement tax benefit, especially for somebody in the highest bracket, would easily pay for the amount you put in to buy it. So that would effectively become your return. That is something just on the surface before you look anywhere else to be very suspicious of a transaction where the tax benefits themselves not only would basically be a really good return, but there's no obvious other return they'll ever get. Right? Doesn't mean it can't work, but it certainly makes it a suspicious transaction that you need to understand a bit more before you just blindly go in and say, oh yeah, that looks good. So they claimed a deduction on 2015 return. They basically claimed very substantial charitable contribution deductions for those easements, $62 million, right? And various other deductions. Now, the IRS examined the partnership and issued notices of final partnership administrative adjustment, FPAAs, disallowing most deductions for failure to satisfy the Section 170 requirements, primarily on, the documentation requirements, and key among that was not having a qualified appraisal. And they asserted accuracy-related penalties. Now, the court's going to apply the following legal principles. First, Section 170A1 of the Code allows a deduction for charitable contributions generally equal to fair market value. But continuing on, there is a requirement if it's a non-cash contribution that's valued at more than $5,000, and it's not a very limited subset of items like stock in a publicly traded company. If it's valued at more than $5,000, it requires a qualified appraisal. More than $500,000 require that that appraisal be attached to the return. So at $5,000, I've got to have the appraisal. At $500,000, I've got to attach it to the return. Failure to comply per the code denies the deduction. So deduction is 0. Now, it's not quite as clear cut, because in this case, the IRS was assigned to write the rules for what would be a qualified appraisal. But there's no question if you don't have a qualified appraisal. Therefore, if basically you don't have it, and that means you don't comply with the IRS regs, or if the court decides it's possible, you might be able to argue substantial compliance. But if you don't have it, the deduction is 0. It's not like in between. The qualified appraiser disqualification rule per the IRS holds an appraiser is not qualified if the donor or the managing authority, in this case, Mr. Collins, the guy who was marketing all of this, had knowledge of facts that would cause a reasonable person to expect the appraiser to falsely overstate the value. This is where things and the order when things happened here became crucial, because in prior cases we've talked about, the court has said, nope, we don't believe that was the case. But this one, they say now they believe this one's prearranged. Now, the valuation principle that we use is for these, and we've talked about this numerous times before, is a before and after approach when valuing an easement. The best evidence of fair market value is the arm's length transaction price close in time to the valuation date. And you have to also consider the highest and best use of the property. So those are key concepts that the court takes a look at. Now, let's get into the disqualification of Mr. Foster, the appraiser, because the court found Mr. Foster was not a qualified appraiser. He's not a qualified appraiser. You don't have a qualified appraisal. Now, you may remember that didn't disqualify an appraisal, or at least didn't totally disqualify things, for an appraisal related to the art that we talked about with that donation to the Metropolitan Museum of Art. But remember, that had a good faith component. This one is going to be a problem. So Mr. Collins and Mr. Foster had a meeting of the minds on the inflated appraisal. In essence, and the meeting of the minds is a term for contracting. In essence, the contract was to effectively deliver an appraisal that agreed with what Mr. Collins had been telling all of the people he was marketing the plan to. And that was done before any actual appraisal work was done. That is, Mr. Foster had no basis, per the court's view, to actually say that that property would be worth that amount, in essence, that the easement would be worth that much, because he didn't really know anything about this stuff at that point in time, right? Now, Mr. Collins knew the true fair market value, that Rockcliffe was less than 1.5 million and JEB was less than 5 million, but he agreed and, made this agreement for significantly higher values. They said the reason why these values were chosen in the court's view was not because they were truly the values that, somebody just sitting there and having no interest in the game and just looking out there and saying, this is what the value will be a year from now when you give this. That wasn't how it was determined. It was chosen specifically to facilitate a marketable transaction, to get a 4.4 to 1 ratio, not to reflect an accurate appraisal. So based on all of that, Mr. Collins had to know that there was a more than slight possibility that the appraiser was going to come in with a higher than market value. And once the donor knows that, the donor can't use that appraisal. Right? So the partnerships, therefore, were entitled to 0 non-cash contributions for 2015 because they failed to secure and attach any qualified appraisals to the return. Right? We just tossed this one out. There is now nothing attached. And as I said, this happens consistently in the charitable contribution documentation areas. If you don't do it right, if you don't have the documentation exactly in the right structure, your deduction goes to 0. Now, I know a few weeks ago we did have that exception. We talked about to the museum, but that was a case where there was reasonable cause why that, the donor didn't know he didn't have a qualified appraisal. Right. And in that case, the court said, fine. But in this case, the real problem is Mr. Collins, right? The promoter. He knew what had been agreed to. He knew how the agreement had been arrived at. And, you weren't going to get this appraisal is what the court is saying in their belief that you weren't going to get to do the appraisal unless you came back with a 4.4 valuation. There was no reasonable cause defense. And so this gets directly to why in the painting, they did go ahead and allow a deduction for the value, but here they're not going to. Remember, the painting was still a much lower value. Mr. Collins' knowledge and actions, including his understanding of the tax opinions, weren't worth the paper they were written on, precluded any reasonable cause defense. Mr. Collins knew exactly that he needed, to market this, he wanted that 4.4. And he went out and negotiated everything based on that. And yeah, there were problems. And yes, generally the tax opinions, especially when they just assume the appraisal's valid, and Mr. Collins knew they weren't, you can't really rely on any of that. So also for other deductions, those were disallowed, didn't go into a lot of detail, but the taxpayer failed to prove entitlement. Mr. Collins for the partnerships failed to show that. Now, having said the deduction is zero, you might think, well, there can't be a valuation misstatement because, there was no deduction would be allowed. That's zero. But, the court works that one out and says, no, that's actually a different issue. And so they're saying we're still going to figure out, because you claimed $62 million. Did you claim a value that was grossly inflated? And the court did determine the correct fair market value of easements. For Rock Cliff, the court determined a value of $960,833, while on the return, the claim value of that had been $14,665,625, slightly overstated. Jack's Creek, because there are 4 different properties here, $1,906,862 would be the value of the conservation easement. There they claimed a value of $19 million, at $19,005,000 there. East Village, the court said the value of that easement was $838,238. The claim value was $16,028,333. And Baker's Farm, the court found a value of $1,074,798. The taxpayer had claimed over $13 million. Because of that, it imposed the gross valuation misstatement penalty under 6662H applied to all the partnerships in this group. Each one of those was a separate partnership. Overstatements range from 740% to 1,908% of the correct value. And you cannot get a reasonable cause defense for gross valuation misstatement. That's one to remember. This is a penalty that can't be waived for reasonable cause. And the 20% penalty under 6662A, was imposed for any portion of underpayment that wasn't due to that huge misstatement. So in essence, the value of the benefit the taxpayers got from claiming the correct portion. That part, which was also disallowed, that also gets penalized, but at a 20% rate, because in that case, the problem was not gross valuation misstatement, didn't put that number on there, that much of it, but rather simply not getting a qualified appraisal. So some critical takeaways here if you're working with your clients to get marketed these. You have to make sure there is no indication of any prearranged or directed valuations. That leads to appraiser disqualification, disallowance of the entire deduction, and your client who invests in the package is going to be one paying the penalties. So, understand that it's important to get clarity about how this was entered into, what exactly happened, and when did you start marketing? When did the first time you started selling this with this 4.4 to 1 ratio? And when did you go contact the appraiser? And when did the appraiser first see any of the properties? Yeah, because if you put that timeline together, which is what the court says, that's the court's findings here. They're saying that timeline indicates that we started with what I needed to have to be able to sell this thing, and I already had the properties in place. And so we just got an appraisal then to make the 4.4 work. Also, arm's length transactions are key. Recent genuine sales of the property are the best available evidence of the before value for penalty purposes. The court's going to scrutinize transactions to determine if they are generally charitable or primarily tax-motivated schemes. If they are tax-motivated schemes, again, theoretically, we can say that, the charity, would have been, if let's say they had gotten a qualified appraisal and the numbers had been the numbers the court found for the value. People might still have invested for tax purposes, though it wouldn't have been the whole bit then. Remember, you couldn't have gotten everything back from just your tax savings from the lower numbers. So if really there was some valid reason why the conservation easements had ballooned in value so greatly, the values of the property had ballooned in value so much over that 1 year, because remember, because of before and after, what we're saying is the value of the property, because remember, the easement is just part of the property. The value of the property had to have gone at least up to those levels. So if there was a valid explanation, would it still be valid? Probably. But as the court, just thinking rationally about this, if it was knowable that these properties are going to increase that much, who would have sold them at the price they were sold to these guys? That would have really been the issue. And if you know that these guys really are spotting these things and they're selling property, and they're selling these easement deals and they all work out, then you're probably not going to want to sell to these guys in the future. So they come looking for your land, you're going to be like, wait, my land's about to explode in value. I'm not selling it to them for only $1 million, right? I'm going to wait and get the bigger numbers. Remember that claiming values of more than 200% the correct value results in the 40% gross valuation misstatement penalty with no reasonable cause defense. So that's a huge problem, right? You got to watch for that. And tax professionals have got to exercise extreme care in advising on these transactions. Point out to clients all the ways like how this one went wrong. And, and the IRS is definitely going after a bunch of them. So it's not like they're not going to examine it, because we've seen a lot of exams go on in this area. You really need to tell them we need to have a lot of details to do proper due diligence, or they risk getting, not only no deduction, potentially no deduction for what they put in, but so their deduction is entirely disallowed, but also then having to pay penalties on top of it. So it's going to be a very, very expensive proposition. So keep that in mind. Now we're going to go into why it's so important to pay attention to all requirements. Just slapping together, and I guess that's kind of how you'll phrase it. I think I know what was happening here, but just kind of, it's not good enough. If you believe, hey, all we need to do for portability is throw in a 706, and we're not going to worry much about it because it doesn't matter, etc., and we're just going to kind of, not really, not pay a lot of attention to the regs, and fill out the forms in detail the way they should be done, as the instructions say, and as the regs offer. We're going to just assume we meet every safe harbor. If you're going to do it that way, you might find out when the second death comes that there's going to be a surprise. And that happened with the estate of Rowland. It's really important to understand that when we talk about doing these 706s on portability, this is the first case I can think of that I've seen where the actual way they handled that portability, because I can see a lot of people deciding, it's just a formality. We're just doing it for that purpose. So it doesn't really matter. This just gets us on the record of having done it. And therefore, having done it, right, filed the form. If there were problems with it or we didn't do it right, well, the IRS, we in the IRS can work that out on the second death. Yeah, turns out in this case, the estate of the second to die didn't get a chance to work this out on the second death. Rather, total disallowance of the DSUE. So this case is estate of Billy S. Rowland, with James Park executor versus Commissioner of Internal Revenue. Tax Court Memorandum Decision 2020-576. Now, this is this basically is, the problem is not so much this estate, it's the estate of his wife who passed a couple of years before he did. That's where it's going to be the problem. So, it's not really the Rowland estate. This estate did something wrong. It was the other estate. Okay. But this case underscores the key importance of strictly complying with filing deadlines and return preparation standards if you are trying to elect portability, of the deceased spouse unused exclusion, DSUE account, even when attempting to utilize the administrative safe harbors. In essence, it's not enough to just get something filed, right? Something filed that says we're electing portability. That's not good enough. Okay. The tax court emphasized an estate tax return must be completely and properly prepared, including full itemization and valuation of assets to qualify for the DSUE portability. And that's true. And even though there's an administrative safe harbor that simplifies the valuation issue somewhat and listing, you got to make sure you qualify for it. If it turns out you didn't, which is going to turn out they're going to rule in this case it didn't, you've effectively never filed a return. You don't get partial credit for having put a 706 into the system by the due date. So let's talk about this. We have now Faye Rowland, in essence, predeceased spouse who died on April the 8th of 2016. And then Billy Rowland, who was the surviving spouse. He died less than 2 years later on January of 2018. Now Faye's executor, who is James Park, sought to elect portability of Faye's DSUE account, which was $3,712,562 for use by Billy's estate when he passed away. So let's talk about Faye's return. Her extended due date for a timely 706 was July 8, 2016. Okay. Now, this actually got filed December 29, July 8, 2017. This actually got filed December 29th of 2017. My guess is that, suddenly it became clear that Billy was not going to survive long term. And so they rushed out to try to get something put together because in the interim, Revenue Procedure 2017-34 had been filed. But under the general rules for filing, this was late. Couldn't meet the standard rules. So what they had to do was attempt to meet Revenue Procedure 2017-34. And that form, which had a due date, essentially they had to get that in by the date it did, received by the IRS on January 2nd, 2018. Generally, that would have been barely under the time frames that they would have had to file this particular return, right? Within 2 years of date of death, I think it was something, or by January 2nd of 2018. So it snuck in because, they basically grandfathered in things for prior returns. If you had died within the prior 2 years and you're late, there were various rules. So anyway, but we got in on time. That was good. Now, this return reflected estimated gross estate of $3 million, but did not include any fair market value for any listed assets, instead listing $0 for each property category. It does show signs of being rushed in, and I think that's probably to a certain extent because it was becoming pretty clear Billy wasn't going to survive much longer, right? Billy would not make it through the end of January, so they got this in play, right? They mailed it December 29th. IRS received January 2nd of 2018, right? So that's where they got in. And the executor could have been the person advising the executor, but we'll say, in this case, remember, executor is still responsible for it, incorrectly applied the relaxed reporting rules for marital charitable deduction property across the board. Okay. Now, Billy's return was timely filed and did report the DSUE amount to reduce how much tax would be paid on Billy's estate. Now, the IRS filed an objection because remember we have a weird number there for the DSUE amount that was eventually claimed on Billy's return. That means there were some assets that passed not to the surviving spouse. That's going to be important here. Now, the IRS notice of deficiency asserted it was ineligible to claim the DSUE amount. The IRS said Faye's return did not make a proper, complete, and effective portability election due to untimely filing under the original due date and failure to satisfy Revenue Procedures 2017-34 requirement. Specifically, there was an absolute absence of complete descriptions or valuation information on the return. Now, we have a unified credit and DSUE under 2010. As you remember, under that provision that was added back many years ago, you're able to carry over, right, when the first spouse dies, any amount of their exclusion that isn't used at their death. It has to be theirs, not theirs in the DSUE, right? So we don't get to just keep going it forever. You could, if you can't pile on a DSUE, have them get remarried, and then have them die at the proper time frame, and then pass it on to the next. You can't build them up that way, but you can do it this way, right? So bottom line, they could get it. Now, to get it under the code, section 2010C5A, the executor of the deceased spouse's estate must file an estate tax return computing DSUE amount. The executor makes an election on that return, and such return must be filed timely. And obviously, timely would have been with the extension July of 2017. That did not happen. But Revenue Procedure 2017-34 provides a safe harbor. It allows a complete and properly prepared estate tax return to be considered timely filed if it was filed by January 2nd, 2018, or the second anniversary of the decedent's death. Well, she died, so they really would have had a little bit extra time to file this, right? Because she died in 2016, but it wouldn't have been very long that they had extra time to file it. And I don't believe the original revenue proc, it was actually clear if it would work if you filed it after the surviving spouse died. I did never say it wouldn't, but it could have been some concern. So there probably was a bit of a rush to get it done before, Billy died, to make sure. Now, complete and properly prepared, per the tax court, requires adherence to Form 706 instructions and specific Treasury regulations. Now, somebody's probably going to be thinking, wait, this is just a revenue proc. Those aren't binding like regs. Except in this case, really they are. Why? Because this rev proc grants you a right that you don't really have under the reg. What the IRS decided was, generally, they can extend a date for doing something if the Congress provides that date in the statute. However, they decided if no 706 was actually required at her death. So we're going to presume that at her death, her estate was less than the amount that would have triggered the necessity to file an estate tax return. Okay, if that's true, then the IRS says, well, if no 706 is required, then there is no due date in the code that Congress provided. So while if a 706 is due, the date is fixed by Congress when we have to make our election. If no return was due, that then is governed by the regulations where the IRS defined the due date for that return that isn't really required, and there's no due date specified by law, and they could waive that date. Now, and that's part. Now, the regulation doesn't really do that, but the IRS said under the general regulations under 301-9100-2, I believe is the right one, in essence, the IRS can, basically excuse and grant relief because it's a regulatory election. So they have this general purpose regulatory election relief granted if you meet these criteria. In that case, this thing is binding because you have to meet this criteria. They didn't apply for a private letter ruling to ask if they could make a late election, which might be a little tougher to get when it becomes clear that now you know facts you didn't know at the time when you failed to make the election, right? So the safe harbor was better because that wasn't an objection to the safe harbor. You can still make the safe harbor election without doing that. Now, the thing that got them in trouble, though, was, so let's say, Revenue Proc 2017-34, they did file a 706. They did file by the due date on paper that was there. The question, though, was, did they really file a 706? And that gets us to the relaxed reporting rule. This is a special rule found in Treasury Regulation 20-2010, 20-2010, right, for Regulation -2A7II. That rule relaxed detailed reporting requirements for marital or charitable deduction property if the estate is not otherwise required of a return. But this rule does not apply if the value of such property relates to or affects or is needed to determine the value passing from the decedent to a recipient other than the decedent of the marital or charitable deduction property. This was the fundamental problem she faced, right? Her estate faced. Because the problem was assets were going other than to her spouse. That's how you get that weird number. It wasn't prior gifts. It was there were assets being transferred to, directly to a non-spouse that would use up part of her exclusion. So the court found her estate failed to make a proper portability election. So we totally ignore the 706 they filed, at the end of December 2017, received by the IRS of January 2nd of 2018. That doesn't count. And since no correct one was filed before the 2 years were up, right? We got a problem. So they can't use the 2017 34 safe harbor. They never filed a correct return. So they failed to complete and properly prepared requirement. No valuation information for each property interest was provided on the schedules. And the executor incorrectly applied the special relaxed reporting rule across all assets. The court found that wasn't a foot fault or who cares? I mean, come on. The IRS will never raise that. I hear that from people all the time when you talk about certain rules. But the problem becomes, what if they do? One thing I have always told every time I'm teaching a course is it's important to know two different things when you deal with the IRS, especially in an exam context, or when you're giving clients advice about positions and the question becomes, what's going to happen? Is this position justified? You need to look both not just at the practical idea, which is where many people stop. I've been in practice since 1982, and I have never seen the IRS question this on all the returns I've done over those years. And I can certainly tell you that. I've been in practice since 82, and I can certainly tell you about rules I've never seen the IRS raise on exam. But here's the catch. You also need to know what they could raise, because it's not really a defense in court to say, hey, the IRS never challenged this on anybody else before. That's probably not going to get you anywhere in the court. And it didn't here. The Rev Proc is clear. And, they're saying, and the regulation was clear. But, I think probably whoever prepared the 706 believed that the big thing was to get something in there by that date. And that, if we happen to get a little bit wrong or it's an error, well, this is really all going to be decided when he dies. So, why worry about all that? That's the problem. Key issue is for relaxed reporting, even for marital and charitable deduction property, that standard did not apply to her trust agreement. The trust provided for percentage distribution to a charitable foundation and Mr. Rowland, with the residue going to trust for grandchildren. You had to know the value of Faye's estate and the property in Faye's estate to properly fund not just Mr. Rowland's, basically the spousal amount, but you had to know how much went to the grandchildren and how much went to the charitable foundation. Right? We had to do that. The value of the marital charitable property relates to, affects, or is needed to determine the value passing to grandchildren's trust. That required a full itemization and valuation of all the property. You needed a full-blown 706. Key, and that's probably the huge takeaway from this. If everything goes to the surviving spouse, then the simplified 706 reporting is fine. But if anything is going to the not to the surviving spouse, and it's not a specific bequest. I mean, I don't need to care what the value of the spouse's property is if I'm just told $10,000, is going to go to this grandkid. The value of the property in whole doesn't really matter to that, I guess, except theoretically if the total estate was less than 10 grand. But hey, if that's true, then I think the court's going to have a tough time enforcing, really getting too worried about this, because there wouldn't be anything going to his estate. So yeah, we're not going to worry about that. but that's your problem. But if you do have this where you have a residual going to, and this often happens, right? We're going to pass residual to the grandkids, but we have some leftover that we want to be able to use at the death of the second spouse. So we want to, pick that up and put it on the second spouse. Yeah, it complicates matters. And they caught it in this case, which is also important, right? The court also found that they weren't really sure substantial compliance would apply here, but even if it did, the failure to provide a fair market value for any property item was not, in the terms of the court, a mere footfall. It frustrated the IRS ability to efficiently verify the DSUE amount. Information provided during exam cannot cure this noncompliance. You can't provide the details on the exam of the second to die. You may say, well, that's crazy, that's not fair, but at least currently, per the tax court, that's where we're at. Right? And the court found no equitable estoppel. The court found no evidence of affirmative misconduct by the IRS. The IRS's silence by not complaining about the 706 related to its legal position, not a statement of fact. So, because they tried to claim, well, the IRS should have told us that 706 was wrong, right? They should have told us that we need to put values on it. No, the court's not going to go there. If the IRS ever told you that 706 was fine, that would have been affirmative misconduct, right? They led you to believe it was perfectly correct. They directly told you it was perfectly correct. That's different than just not telling you it's not. But if they had firmly told you it was fine that way, there's no problem, these rules are perfectly okay, and they're never going to do that. But if they had, that would have allowed an equitable estoppel claim. So the court granted the commissioner's motion for partial summary judgment, which essentially threw this part of the dispute of the estate out and said there is no DSUE. Faye's return failed to make a timely DSUE election, meaning Billy's estate could not port it. So that whole amount goes off Billy's 706. Now, there are still other issues going on in this case, because that's why it's partial summary, but we got rid of that one. So the key implications: got to make sure you get things timely filed. Always true, right? Again, we know for sure that if we don't get it timely filed, right, our DSUE election won't be valid. Now remember, however, if you do miss the original filing date and you miss the special relief, which now is actually 5 years after date of death, the IRS still has the authority if you get a private letter ruling, but you want to make sure you get that ruling to make your DSUE election valid from them. Make sure the 706 is complete. Portability return, this ruling makes it very clear, strictly, it's got to be, complete and properly prepared. That includes providing the necessary fair market values for all assets, not just estimates. Unless we're in the case where everything, it was the I love you will. Everything went to the surviving spouse, right? That's the case. Right? The relaxed reporting standards for meritable charitable election property is highly limited. It will not apply if the value of that property affects any other beneficiaries. So if there are fractional shares or residuary bequests, right? We have to divide it between, let's say, the amounts going to the surviving spouse in trust with a Q-tip election attached, and amounts going to other beneficiaries that are using up the exclusion, right? And that's got to be determined by looking at, if we're going to have 25% go to the grandkids and 75% goes to the other trust, then we got to know the 100% number in completely. So that's also a problem. You can't cure non-compliance. Any substantial omissions on the original return, like the missing valuations, cannot be cured by later providing the information on exam. You have lost the ability to make the election. Remember, the key thing you're trying to defend here is the right to make the election. So it's not really, the election requires full disclosure in the form the IRS requires for the 706. And if you don't do that, then we have a problem. Now, a little more interesting question might be, because the revenue proc is what they used, would they have had a better chance had the original return been filed on time? I will tell you that question has not really been answered by this court. Right. And it is subtle, but it's important. So you might want to try to make sure you get, you get these portability forms filed within the regular due date of the 706, and not necessarily want to rely on the rev proc, because I think you'll have a little bit more leeway if you go, with the filing, on the regs. It may make no effective difference by the time we're done, but at least you have a chance of arguing that under the reg, it's a different set of rules. Under the reg, then we're there looking at the validation and looking at whether you could have substantial compliance with the reg as opposed to substantial compliance with the revenue procedure, is that case. And make sure the 706 is very carefully prepared, especially when fractional or residuary bequests are involved and you're trying to elect portability. Really important to make sure that is a proper return. Okay, this goes into you win some, you lose some, and sometimes you end up doing both in the same case. This is a case of Boechler PC versus Commissioner. And Boechler may sound familiar because you might have remembered it was a Supreme Court case a while back. Now, this is Boechler PC versus Commissioner of Internal Revenue. It was a tax court bench opinion issued on June the 12th and got published this week. It's docket number 18578-17L. And this is the return of a case that went to the U.S. Supreme Court, right? The Supreme Court ruled, what the tax court had ruled in the original Boechler case was that she had filed for her collection, she had filed to basically get take her collection matter to the tax court outside of the time period for filing the return per the statute. Tax court said we have no right to consider equitable relief issues on that. So because of that, we can't hear your case. Not only can we not hear your case, we can't hear any discussion about why equity suggests you should be able to file this petition and have your case heard. So the Supreme Court said, nope, the way we read this particular section that involves this part, we don't see that it's barred to use equitable considerations. So the fact that you dismiss this case by saying you can't consider equitable items means that, sorry, you dismiss it on the wrong grounds. We're sending it back. So, but all it said is, Supreme Court said, well, a 30-day deadline for collection actions is subject to equitable tolling. It didn't say she qualified for it. And as we're going to discover, the bar for its application is extremely high, requiring demonstrated diligence and truly extraordinary circumstances beyond a litigant's control. Really, really crucial for tax professionals about the stringent standards for excusing missed statutory deadlines. This, by the way, the corporation's case, Boechler PC, law firm. Okay, basically a one-person law firm is what it was. Now, Boechler PC was a sole practitioner law firm in North Dakota, led by Jeanette Boechler, right? Now, the commissioner initiated collection action against Boechler PC for failure to timely filing information returns for 2012, leading to penalties. The commissioner mailed a notice of determination dated July 28, 2017, sustaining the notice of intent to levy to collect this. Notice especially stated petition to tax court was required within a 30-day period beginning the day after the date of this letter. That 30-day deadline would have been August 27th of 2017. That was a Sunday, right? Okay. Now, Boechler's counsel, Boechler PC's counsel, who was Jeanette Boechler, okay. Remember, Jeanette's going to wear two hats here, right? Mailed a petition on August 29th. She's one day, she screwed up the count, right? She didn't count her days right. She thought she had till Tuesday. She only had till Monday, right? So she ends up doing it 32 days after the notice date. And the tax court received it on September 1st. The IRS obviously, moved to dismiss, saying she filed after the 30 days. Essentially, she can't, now she's got to pay the amounts and sue in district court if she wants to continue to contest this. Right. Now, she testified she miscalculated the deadline, believing it to be the 29th or 30th. Okay. Now, okay, she says, I just got it wrong. I made a simple mistake, right? She may have decided, and we don't know, but things like, well, you got 30 days. She may have counted from the day she received the letter. Letter got delivered. Don't know how she calculated and why she got it off, but she did. She missed it. So she attributed this to her demanding professional life. She's a sole practitioner and has a heavy caseload. I think a lot of us could say, yeah, we understand that as CPAs in tax. Yeah, if you're a solo practitioner, you got all these clients yelling at you for where's the return, and where's my stuff? Why don't we have it? And her complex personal life. She was a single mother. She was a primary caregiver for her elderly mother as well. So she said there was just a lot going on. Come on, I just missed it by, I missed it by a day, essentially, right? I mean, because I would have had Monday to do it. So I did it on Tuesday, a day late. Well, the tax court initially granted the IRS's motion to dismiss, asserting lack of jurisdiction due to the untimely petition. And when she appealed that ruling to the Eighth Circuit, they affirmed it. Well, the Supreme Court, granted hearing on this case. Now, the deadline to petition tax court under Section 6330 for this is not jurisdictional and is subject to equitable tolling. The rationale that they gave for 6330, there was no express statutory prohibition to equitable tolling. The short 30-day deadline is directed to the taxpayer, and Section 6330 is unusually protective of taxpayers, and litigation often involves pro se litigants, which she was and wasn't. Corporation, kind of weird. Yeah, we'll get this case, right? But it doesn't matter that she was an attorney. It says quite often there are going to be pro se litigants who are going to make the mistakes of the type that Jeanette made, right, in other situations. The case was remanded so in essence, the Supreme Court sends it back to the Eighth Circuit because that's whose ruling was basically overturned. The Eighth Court said, well, we don't hear fact issues. They sent it back to the tax court specifically for fact finding on the question of equitable tolling, right? And when equitable tolling takes case, it effectively extends an otherwise discrete limitation period. So it's a background principle against which Congress drafts limitations. The question becomes, is limitation Congress imposes, especially on the tax court, which is, of course, limited jurisdiction, is that statute meant to be absolute, or does it, just automatically pick up equitable tolling as a defense? Now, non-jurisdictional deadlines are presumptively subject to equitable tolling unless rebutted by the statutory text or its scheme that's involved. And there are two key elements for the petitioner. To be entitled to equitable tolling, a taxpayer must establish both. Now remember, the Supreme Court's already ruled that equitable tolling is in play here. So we're kind of past the first two bullets. We have the presumption is that this is a non-jurisdictional deadline. They're subject to equitable tolling, right? So she doesn't have to prove it's not jurisdictional. We've already had that holding by the Supreme Court. But even having done that, to be entitled to equitable tolling, she has to show diligence and extraordinary circumstances beyond her control. So for diligence, the party must have pursued its right diligently. That requires taking all reasonable steps to ensure timely filing and actively engaging with their attorney. I understand with Jeanette and her PC, this is going to be a little weird about the PC actively engaging with the PC's attorney. Jeanette as president of the PC engaging with Jeanette as counsel for the PC. But except we got to still play out that fiction. And there must be extraordinary circumstances beyond the party's control, right? Outside of the party's control that prevents a timely filing. They have to be both extraordinary and beyond the litigant's control. Equitable tolling is not normally applied. The theory is there is a reason why there was a 30-day deadline. Failure to satisfy even one of those two elements will disallow the claim. So while Jeanette is allowed to argue this now, that didn't make the argument any easier to win, right? That will turn out to be the problem. Now, the court found she failed to establish the first key of diligence. They found no evidence that Boechler PC diligently pursued its rights. There was no evidence that Ms. Boechler, the attorney, Ms. Boechler as president, followed up with her attorney, Ms. Boechler as attorney, or staff to ensure timely filing. And it really would have required action by her, to have done something to make sure things got filed on time. We'll be there. Now, she couldn't recall if she personally filed it or if she merely supervised the filing. So we don't know, maybe the problem was, she gave it to her staff member, a member of her staff, the staff person just, I don't want to go to the post office today. I'll take it tomorrow. What difference could it make? Could be a big one, right? That's a possibility. So she didn't recall how it happened, which is interesting. It's like that. I mean, do you normally take things like this to the post office or, okay. Yeah, and I suppose it could be that sometimes she takes filings to the post office on her own. Sometimes she has the staff do it, whichever. So there was no indication of specific instructions to counsel. Now, as I said, it is really odd thinking about this because remember, Mitch Boechler, as corporate officer, was supposed to document her instructions to Ms. Boechler as counsel. Yeah, but in any event, they didn't find she pursued her rights. And fundamentally, they're going to basically find that an attorney, calculating the day it was due should not have been outside of her ability. So it was there. Now, and she also found they didn't see extraordinary circumstances beyond her control, even if she did act diligently enough. While her mother, okay, let's talk about a caregiving. Her mother was elderly, other family members assisted. So she was not the sole one. While she might have primary, she didn't have sole responsibilities for care of her elderly mother. Because others did assist during that time period, right? That was not an extraordinary circumstance. Her oppressive workload, gang, court's going to tell you, as a sole proprietor, in this case, she controlled her workload. The fact that she took on too much work is not an excuse for her not filing the return on time, right? She controlled her own workload. She shouldn't have taken on as many clients, is essentially what they're saying, if that didn't allow you to do these sorts of functions. The extraordinary caseload was not by itself. It existed because Jeanette just took on more clients, right? And the miscalculation of deadline, the court was very clear. Miscalculating deadline is not extraordinary circumstances outside of one's control. Eighth Circuit precedent supports this, finding an attorney's miscalculation was insufficient for equitable tolling. Gang, here we have an attorney's miscalculation. Now, she might not have been a tax attorney, but same difference. It's like, didn't really need specialized tax skills to understand 30 days after the date of the letter, right, was it. And theoretically, I'm sure the court would have held, well, she obviously could have checked the statute. 26 USC 6330 should be every attorney should be able to find that, right, and do basic research on that part of the U.S. Code. So essentially saying, now we're not going to allow that one. So the court said, tax court ruled she satisfied neither of the requirements for equitable tolling. Therefore, even considering equitable tolling, her petition was untimely and decision was entered for the IRS. Practical implications, don't ever rely on equitable tolling. By definition, if you rely on it, you think, you say, oh, we don't have to worry about getting this filed on time, we'll get equitable tolling. No, try everything you can to not have to go down this path, because the odds of winning going down this path aren't high. And document clear records of all actions taken to ensure timely filings, including, in this case, as ridiculous as it was, Jeanette should have sent memos to herself and her staff regarding the date by which this thing had to be filed, etc., clearly communicating that, taking on top of it, that she consulted, she had them verify maybe, whatever, some member of the staff could have been involved in verifying dates, etc. Yeah, I mean, I don't think it would have really helped her, but really it should be there. Definitely if your client is relying on outside counsel, then yes, they should communicate, keep their communications in that regard. Practical implications for all of us, busy is not an excuse, right? Personal and professional demands, even severe ones, are generally not considered extraordinary circumstances for equitable tolling. That's doubly true if you're a sole proprietor and you're the one ultimately completely in control of your client load. You just terminate clients, right? You don't take them on. And bingo, you're in control. Double, triple check all filing deadlines. Miscalculation is the taxpayer's responsibility. Make sure you don't just assume a deadline. You double check it. You have somebody else check it with you, right? Just give it to somebody else and make sure you're reading it right. Verify this, right? Built-in buffers and contingency for filing deadlines to avoid last-minute issues and missed deadlines. That's probably the biggest thing, although I know it's really tough for a lot of professionals to do because they do keep themselves so busy that they always file things at the last second. But, Had she simply, just filed this thing, she knew she was going to file it probably well before it was done. Had she just taken the time and done it a week earlier, there'd have been no problem. There is always dangerous when you decide you're going to file something on the last day to give yourself that extra, day or two to do something. If it backfires, you're in trouble. Next, now this case to me is not so interesting for the facts. It's going to be another conservation easement case with the result that we've seen multiple times before. What's much more interesting is when the court goes off at the end of this thing, right? Okay, so it is Veribest Vesta, whoever decided to name that thing, LLC versus Commissioner, right? In this case, there is a huge warning added at the end of this case for anybody considering litigating a conservation easement where it's fairly easy to suggest that the court is likely to find that you wildly misvalued the property. And, in this case, the court will literally threaten basically the tax matters partner here who promoted a number of different of these, a bunch of which are still to come before the court, and the counsel that represents them in those cases, that they need to seriously consider that there is a high risk if they keep bringing these in, that the court is going to have the attorneys and the plaintiff make them personally liable for all costs incurred in litigation. That's a big warning. So let's take a look at this case. Right. The tax court firmly rejected a $10 million conservation easement valuation as a gross valuation misstatement, and it highlighted its low opinion of speculative and unsubstantiated appraisals. Now remember, this is $10 million. We had a $62 million one with an unqualified, with not a qualified appraiser, and the court didn't really go off like this because this is a case where it sees a whole bunch more coming that look awfully lot like this one. Crucially, the court's consideration of sanctions under 6673 against both the petitioner and their counsel is a huge warning about, we'll take it to tax court, right? You've got frivolous positions and baseless valuations, and the court is sending out a big warning sign that they are about to view litigation like this as frivolous, done primarily to, delay, ultimately the finding that that the deductions are going to all be disallowed. And they are talking about actually imposing some severe sanctions. Now, again, I don't know if the court would really be able to make those stick, but it does show a high sign of frustration. And probably, especially if one of your clients is being marketed as shelter, it's one of these things kind of show and say, yep, it has, we have lots of things, and this looks a lot like what went down here. Okay. Now, Veribest Vesta was organized in October 2017. It held a property, the Old Grimes Quarry, 66 acres in Elbert County, Georgia, known as the granite capital of the world. Now, the history. Mr. Tillman, who was actively involved in granite quarrying, owned the quarry since 2007 and previously conveyed parts to his family business. He later conveyed the entire property to Veribest Vesta, in which he held an 86% ownership interest in December 2017. The purpose of the entities were solely focused on generating a charitable contribution deduction through the conservation easement donation. Shortly after acquiring the property, Veribest Vesta donated conservation easement claimed a charitable contribution deduction of $10,420,000 for 2017. This valuation relied upon optimistic projections for a dimension stone extraction, estimating a before value exceeding $10 million and an after value of less than $200,000. Okay, so we've seen this before, where they are saying the value of this based upon this business that does not exist. Nobody's done it here yet, right? And then trying to discount the value of that business, saying, well, they would pay X dollars, and because the business is worth this much, they would pay this much more. Now, we've had a lot of discussion by the tax court about how they don't buy this, principally because they say, why would anybody pay the full discounted cash flow for the business? When nothing's there yet, they couldn't make money off the deal is the theory of the court. It wouldn't be a net moneymaker, right? The court reminded us, again, difference between fair market value of the property before and after the easement donation. And the price is a willing buyer and willing seller with reasonable knowledge and no compulsion. Fair market value is a question of fact. And the highest and best use, which is what they try to get these theoretical businesses under, they're saying the reasonably probable legal use that is physically possible, financially feasible, appropriately supported, and results in the highest value. Okay. Now, the valuation methods, income capitalization methods, the court has made clear, is generally reliable for a going concern business. There is no such operation on this property right now. That's your problem. Comparable sales method is the best evidence of fair market value comparing to recent sales of similar properties. The court has previously rejected the income capitalization method for a theoretical business, right? That doesn't do it. Now, the gross misvaluation penalty, we've already talked about that. If you claim the value on return that's 200% or more of the correct value, if the taxpayer can demonstrate reasonable cause and good faith, well, not really totally in this case, right? We've talked about that before, but the court makes that statement, so we'll leave it here. But in this case, yeah, it wasn't there. This is the court's ruling. If you actually take this section, that's not quite the way it works. Now, highest and best use. The taxpayer asserted highest and best use as an operating dimension stone granite mine, which amazingly wasn't there. The taxpayer never used it that way, and they'd owned it for years. The commissioner's expert found that HBU was for crushed stone extraction, not dimension stone. And the court's finding was the granite was coming loose with infrequent imperfections, making it unsuitable for commercial grade stone, dimension stone. No evidence supported the taxpayer's highest and best use. Okay. The commissioner's valuation expert, who's credited, they went with his, valued the property at $400,000 before and $65,000 after the easement, resulting in an easement value of $335,000. It was supported by Mr. Tillman's prior offers he'd received and Veribest Vesta's acquisition of comparable land for $3,000 an acre. In essence, the only sales were much more in that range. So, the offers he'd received and, what he acquired stuff at, it's like, yeah. So we're going to get there, okay? Now, projections for a dimension stone quarry were deemed excessively optimistic and speculative. They failed to account for huge upfront costs of $1.6 million. Let's say that dimension stone quarry had been the best use. You still had to put $1.6 million into it to get it done, which they never accounted for that. And it was contradicted by their own prior offers and their acquisition of comparable land at significantly lower prices, right? So it's like, no, that doesn't make sense. The court found that Veribest Vesta failed to meet the bona fide business requirement. They found that it didn't exist for any reason but to generate a charitable deduction, not to engage in any sort of business, right? So it determined the easement value. It accepted what the IRS came up with. The value was $111,000. Remember, they had claimed $10,420,000. The claim value was 9,380% of the correct value, way over the 200% threshold. Or included the claim value constituted a gross valuation misstatement and imposed the related penalty, and failed to establish for any of this any sort of reasonable cause and good faith. And again, for valuation, for the most part, that's not going to help you anyway, right? Now, the commissioner also requested sanctions under 6673 to both the petitioner, Veribest Vesta LLC, and its counsel. The court explicitly stated it will hear further from Commissioner's counsel regarding the imposition of Section 6673 penalties against the petitioner and their counsel. The court specifically noted that there was a ton of wasted time for a lot of parties, and while the attorneys for the plaintiff were getting paid, the attorneys for the government were getting paid too, there was a huge waste of court time, and there were witnesses that were required to travel to the court location, to testify about various facts that had to, basically give up that uncompensated to come in. And they said, we want to seriously consider this, and very carefully warned about, that those future cases, just be very careful there, right? Conservation easements are a super high risk area. If you haven't gotten that idea yet, you should. Overly optimistic projections or valuations not grounded in reasonable assumptions and market data will be rejected. Highest and best use must be objectively supported by the property's characteristic and market reality, not merely speculative plans that don't currently exist. We got to have something better than that. Market data will be the most important thing. It's really tough to tell me why, this is a $10 million value when nobody's willing to buy it for $10 million. We can't find a single other third party who's paying anywhere near that or ever offered anywhere near that for this property. And, let's be honest. If it really was worth $10 million and we could sell it for that entire amount, would we really be making a charitable contribution of it? And would people be buying it to contribute it? If in fact we know, we buy it today and it's going to go up by nearly 10,000% in value, would you really say, go ahead and contribute to charity? No, I'd say sell it. I want that return. So that's part of the problem. Beware of tax product entities. And that's kind of what this got called by the court. An entity formed solely to generate charitable contribution deduction, lacks a bona fide business purpose. They're highly vulnerable to challenge. The tax court has said it's going to be much more willing to impose Section 6673 sanctions directly on counsel for frivolous positions. So there is professional risk for advisors. And again, if your clients offered something like this, be very, don't just accept things at face value. And I would always warn a client. I remember an attorney years ago who was offered up his client wanted to get in this tax shelter that they were telling him was going to save him this huge amount of money. And, the attorney, and so, he asked, well, is this a good thing? The attorney, and he said, well, I really can't, I'd have to study it in detail to figure it out. He said, well, they got this legal opinion from another attorney. That's good enough, right? He said, okay, tell you what I could do. I can study that legal opinion in detail and tell you if I believe it would be reasonable to rely upon it. But I'll tell you what, it's going to take, because you notice how thick it is, it's going to take me many, many hours to go through and fully analyze it. You will pay for every one of those. And I will tell you right now that I have gone through those, more than one for previous clients, those sorts of opinions. And I have yet to find one that actually could be relied upon. Your choice. But you're going to pay me up front for the time it will take me, to go through that thing. And I'm telling you, I overwhelmingly believe the answer will be sorry, doesn't work. It's your choice. Needless to say, the client decided not to, not to invest in it and not to actually pay the attorney to go through it. Okay, let's talk about Revenue Ruling 2025-15, right? This helps if you're a retirement plan administrator, right? It allows you to withholding and reporting for uncashed retirement plan distribution checks, right? What happens when you send that check out and the participant never cashes it or loses it or puts it away in a corner, whatever. So somewhere then they finally uncover it probably a year and a half later. Okay. Well, this is the clarification for plan administrators and tax professionals regarding what happens. Let's say that had withholding on it. There was a 1099-R. What exactly do? We issued a retirement check. We, sent the withholding to the federal government. And then the client, and then the former participant doesn't cash it. Right. So what do we, and then eventually we have to replace that check. It establishes this ruling basically the initial reporting obligations are final once remitted, regardless of whether the check is actually cashed by the recipient. So, right, you can't file a claim for refund because the recipient never cashed the check. Right, you can't get that withholding money back. Okay, the scenario they lay out is they're going to have an employer, they call them M. Employer M is the plan administrator of Plan X, which is a qualified employer-sponsored retirement plan under 401A. Standard profit sharing / 401k plan, defined benefit plan, we don't really care. It's a 401A plan. Individual C is a U.S. person with accrued benefit $800 in Plan X. No withholding election or investment in the contract has been made, right? So there's that. It doesn't have withholding election made. There was no investment in the contract. His initial distribution was made by the plan to C in 2024. The employer, M, the plan administrator, initiated $800 designated distribution. Federal income taxes were withheld from that distribution as required in Section 3405. The withholding was remitted to the U.S. Treasury. And check one, the first check was for the remaining balance, was mailed to individual C. That check was not cashed within 6 months of its issue date, right? So now it's too old, it's stale dated. So the sponsor canceled that check after 6 months. Subsequently, the employer essentially issued and mailed check 2, representing the accrued benefit at the time of check 2's issuance, net of any Apple withholding, right? Now, in this case, though, individual C did not accrue any additional benefit under the plan after the initial distribution. So what that means is, upon subsequent reissue, his accrued benefit was still $800. Does the employer have a right to get the first withholding back? Does the employer need to recompute withholding on the second check, or now compute withholding on the net check, again, and withhold again? I mean, what do they have to do about it? How they have to deal with that? It's going to issue a check. How do we work that? Okay. Now, generally, 3405 requires federal income tax withholdings on designated distribution or qualified plan. The administrator is generally responsible to make sure that happens. Now, what they hold is there is no adjustment or refund for withholding on the first check. Any adjustment would be under, an adjustment would be under 6413A. An adjustment would allow you to apply it to the later run. That's not available. Because remember, under our facts, the plan sponsor withheld the exact amount required and remitted it. Adjustments only apply if more than the correct amount was withheld and reimbursed, or if an administrative error occurred, neither of which happened in this case. Now, for refunds, those are justified under 6413B or 6414. And again, it rules that's not available for that first check. These sections apply, either one of them, only if the amount paid to Treasury was in excess of the amount deducted and withheld by the employer, and it wasn't. What was transmitted was exactly what was withheld. So the conclusion, no adjustment or refund is available for amounts that are properly withheld and remitted for check 1 simply because it was never cashed. Right? We're done with that. Now, what about check 2? If the accrued benefit at check 2 is less than or equal to the amount of check 1, no federal withholding is required. The initial withholding covered the initial distribution. If the individual's accrued benefit at check 2 issuance is greater than the amount of check 1 due to additional accrued earnings, that excess is a separate distribution subject to withholding under 3405 at the time that second check is issued. So let's say the value of the account had gone up from, his benefit had gone up from $800 to $900. Then if 20% had been withheld, the extra $100 distribution would be considered the gross distribution and would get a new 1099-R, by the way. But then $20 would be withheld from that. Right? That had been the additional 20% that would have been due on a $900 distribution. Right? Generally, 6047D mandates filings, returns, and reports to 1099-R for distributions of $10 or more. That requires reporting the total distribution in Box 1, taxable amount in Box 2A, and federal income tax holding in Box 4. For the first distribution, let's assume it occurs in 24 and the replacement check comes out in 25. The 24 1099-R would report the $800 designated distribution in Box 1, right? The same $800 is reported in Box 2A. No investment contract, no income exclusion, so it's your taxable amount, right? For income tax, be reported in Box 4, right? And reporting requirement applies regardless of whether check 1 was returned as undeliverable or remains uncashed. 1099-R still must be issued. If you have issued that check out to the beneficiary, you have, attempted the delivery, and you've made the withholding, 1099-R still goes out. You can't say, please send us back to withholding. That doesn't work. Check 2. If your accrued benefit is less than or equal to the amount of check 1, nothing goes on a 1099-R. So if he puts a replacement check out in 25, the balances have not changed. There is no 1099-R for 25. Right? If the individual accrued benefit at check 2 is at least $10 greater than the amount of check 1, that excess amount will trigger a 1099-R for the year 2, for the check 2 distribution. So you would have had a 2025 1099-R in my example of $100, $100 gross distribution, $100 taxable distribution, $20 in federal tax withheld. Right? So key holdings here, no adjustment or refund is available for amounts that are properly withheld and remitted, even though the guy didn't get the check, and in essence, it was undeliverable, whatever reason, or they just didn't cash it. Withholding for the second check applies only to the excess amount if the accrued benefit is now greater than it was when the first check was issued. You always must report the full designated distribution for check 1 in boxes 1 and 2A under these facts for 1099-R for 2024, and withheld tax in box 4, even though you know the check's never been cashed. You still have to report it, right? And reporting for check 2 only applies if basically to the excess amount. So again, you have to have more than $10 additional distributed. And if that's true, then there will be a second 1099-R issued for that second distribution. So again, and this just clarifies, because there was some confusion by people, and people were trying to claim refunds and stuff and pretend that first check was never issued. And no, you don't wipe that first check off. The act of properly withholding remitting tax on a retirement distribution effectively completes the initial tax event for the plan, right? Irrespective of whether the check ever gets cashed. That's simply the way it is. A subsequent increase in accrued benefits due to earnings will trigger a new withholding and reporting obligations when you reissue. But if you don't have that additional earnings, you're just reissuing essentially the same check, there's nothing to report on the second distribution. Okay. So, key issues and takeaways. Plan administrators should always complete Form 1099-R and remit withheld taxes promptly for the initial distribution, even if they anticipate the check may go uncashed, right? Because again, yeah, you can't just well, I'm not going to actually send the federal withholding in until I see if they get this check. If you've issued it, you got to transmit over. There's no undo for withheld tax. Once the tax is properly withheld and remitted, the plan administrator generally cannot obtain an adjustment or refund for those amounts, even when the check is not cash. Reissues. When you reissue an uncashed distribution, you assess the accrued benefits increase, and if so, withholding and reporting are only for that increase. Accrued earnings, be carefully mindful of any benefits that accrue on the uncashed distribution amounts, as these will be a new reportable and potentially withholdable distribution, and maintain detailed records of all distribution attempts, uncashed check statuses, tax remittances, and subsequent reissuances. But yeah, you don't just pretend the check was never issued and get your withholdings back. That's not going to work. Okay, the Fifth Circuit ruled out a micro-captive insurance plan, right? Swift v. Commissioner. This is another case where the Fifth Circuit finds, just like the first case we started with today, that this is a tax shelter and one that's not likely to hold up and doesn't hold up to the storm that it faced when the IRS examined it. So this will be it. This case, though, is mainly big, and the main reason I've included is because the Fifth Circuit did finally tell us about when supervisor approval must be granted in the Fifth Circuit, because we have a bit of a circuit split on that test, but we'll talk a little bit about what they decided, right? So the Fifth Circuit affirmed the tax court decision. It found that the micro-captive arrangement was not actually insurance. There was no true risk distribution, and the arrangement did not adhere to substance over form principles. It tells us that the courts are going to strictly scrutinize this arrangement. And the one thing that really does make this a reported case by the Fifth Circuit is it provides the supervisory approval requirement under 6751B. The case is Bernard T. Swift, Kathy L. Smith versus Commissioner of Internal Revenue, case number 24-6270. This decision came down on July the 16th. Okay. This is when we have this decision. So in this case, we have Dr. Bernard Swift, his wife Kathy, and essentially his business, the Texas Medical Clinic, an urgent care center, and two smaller entities. Right. Now, Dr. Swift was approached as he formed two micro-captives, Castle Rock and Stonegate, in St. Christopher and Nevis in 2010, owned by Trust for his children. He engaged Celia Clark, a lawyer specializing in captive formation, in setting these things up. Now, captive insurance policies are kind of, what we said, right? They're essentially effectively under the control, related, but we're going to set them up to insure for risks, right? So we own our own insurance company for certain specified risks. And the captives entered various policies to the clinic, including medical malpractice coverage, tail policies, right? After he would retire, leave after the regular policies go away. And actuaries from KPMG determined the pricing for that tail policy. And then non-medical coverage, policies for administrative actions against the clinic, including the IRS exam, business income, terrorism. They were often priced by an actuary, Alan Rosenbach, who received total maximum premium targets from the attorney's team. If that sounds like a bad fact, yeah, that's a bad fact, shall we say, that was there. It starts to sound a little bit more like, well, what's the appropriate premium? What's the actual premium for this risk? Well, the attorney's telling you what the number they want. Just kind of like, you remember the first case we talked about to start off this broadcast, we talked about the fact that they gave the appraiser the number they wanted. So again, not a good thing to give them the number. It's different if the actuary comes back and, tells you that, a reasonable policy charge could be from this to this. Okay, then maybe, you can select within the range. But, if you just tell them the target right off the bat, yeah, that's kind of the issue. What you've really done in that case is gotten rid of the expertise. And suddenly you're not relying on the actuary anymore, but you're relying upon, in this case, counsel. Because counsel gave the target. So, that was, and probably counsel got the target from tax advisors for the doctor. So, yeah, I mean, you realize you're not really relying upon the expert. That's why it's a bad fact in court, right? Reinsurance pools. The captives participate in Clark-affiliated reinsurance pools, ones that she was involved with. Remember, she's basically the person designing and promoting this arrangement, right? So it had Jane Emerald to achieve 30% of premiums from unrelated businesses as interpreted by Clark, the attorney, for this arrangement. And that is one of the requirements to get the really, really nice tax treatment for micro-captives, for micro-captive insurance companies, right? So from 2012 to 2015, the clinic paid just under $6 million in premiums to the captives. But they submitted only 3 claims that totaled $339,224, including one for an IRS audit, right? Now, the IRS action, it disallowed the premium payment deductions and imposed a 20% actuated penalty for negligence or a substantial understatement. Taxpayers disagreed. We end up in tax court. Now, what constitutes insurance? For a premium payment to be deductible as business expenses under 162A, they must be really for insurance, as the court phrased it. The Supreme Court precedent says insurance, by definition, involves risk shifting and risk distributing. If you don't do that, it's not insurance, right? We do talk about self-insuring, but that's really not having insurance, right? If you have self-insured parts, then generally, you're kind of doing it on your own. You're going to cover that. Yeah, so yeah, in one sense, it wouldn't make sense for me to pay, well, I'm not going to have health insurance this year, so I'm going to set up an LLC, and instead of, I'll transfer to that the insurance premiums I would have paid Blue Cross, I'll put into there, and then I'll pay my medical expenses out of there. Well, you might guess, and then if anything's left over, I'll take it back. It's like, well, that's just basically paying out of pocket. It's like, that's not insurance. There's no risk shifting. By its very nature, why paying Blue Cross for my insurance is considered insurance is because, the money goes in and it's risk shifting, right? If it turns out I have medical premiums and I have medical costs this year well in excess of what I paid in, then that money is effectively coming from other people in that pool, at least that's what the insurance company hopes, who had significantly lower medical costs. And generally you're going to find the vast majority of people paying into the insurance pool will have lower medical costs than the amount they pay in. Now, if you say, but I'm on Medicare, that doesn't work. It's like, well, Medicare is a special case. It's subsidized. So that's not really the cost of the insurance. Over time, you expect to pay in with insurance, with the law of big numbers, you would expect to pay in, on average, the average overall for everybody is that they paid in slightly more than what was paid out for benefits. So you expect to be worse off. Always have fun explaining that to people. But you expect to be worse off. But you're okay with that because while I could be a little bit worse off every year, which I can handle, what I couldn't handle is having to pay for a quadruple bypass out of pocket. That would be disastrous. So I will accept a small loss every year, right? Or it could be a loss all the way up to the whole premium. But I can afford that premium, right? I can't afford the quadruple bypass, paying totally out of pocket for the surgeons and the hospital time and rehab time and all that other stuff. So that's why I have insurance. Now, the tax court put the criteria. These are the 4 they'll generally consider. Is there risk shifting? Did the insured transfer a risk of loss to the insurer? So the risk has moved, like I said, with Blue Cross, the risk of that quadruple bypass, which is highly unlikely I'll have this year, but the risk I might have it has been moved from me to Blue Cross, right? Risk distribution. Blue Cross, in this case, did the insurer, Blue Cross in my case, distribute the risk among a sufficiently large group of independent risk, relying on the law of large numbers to predict losses? And yes, they do. There are a lot of people insured by the Blue Cross I'm with here in Arizona, right? And that law of large numbers is done so that they are okay with the risk that they're going to get from me way less than the cost of that quadruple bypass, because other people will fill in. And I will tell you now, reveal it for myself, that only 1 year, and I've been insured by effectively Blue Cross Blue Shield of Arizona effectively for my entire life except 1 year. It goes way back. My parents had a policy. The firm here I started with had that. I'm still on a policy with Blue Cross. And only 1 year out of that entirety was there ever a year where my medical expenses were greater than what Blue Cross paid. In fact, in most of those years, Blue Cross paid extremely little or actually nothing. Right. But again, I'm covering for those quadruple bypasses. For people that had quadruple bypasses, so they're not totally destroyed by having that happen. It must be a genuine fortuitous risk of loss. It's not risk shifting if there's no real risk or the risk is wildly remote, right? And it must resemble the commonly accepted notions of insurance. My case, Blue Cross, clear risk shifting, clear risk distribution. It's a genuine insurable risk. A lot of that going on. Yeah, we have lots of medical insurance sold out there. And it's under commonly accepted notions, right? So we have that. It resembles what we expect to have. Risk distribution is essential. The micro-captive does shift the risk, right? But, we may say ultimately it doesn't because it's all really, the doctor in this case is the problem, but it does shift the risk. But the fact is there's no distribution among others. The insurer, that's not really distributing risk, right? So that's the problem. Now, the tax advantage being a micro-captive, which you'll find under 831B, is premiums under a certain threshold, $1.2 million for the years it issued, are not taxed at the captive level. Clearly issued. $1.2 million could go in to pay for premiums in the micro-captive, and no tax will be paid by the micro-captive, and that can lead to effectively tax-free income if the insured can deduct it. So we're getting a deduction and we're pushing it away into the micro-captive. So yeah, it's like, wow, we're like, this is working kind of like a retirement plan, except there aren't all those nasty other rules, right, that come with it. Now, the tax court and the Fifth Circuit came to an identical conclusion in this case. The captive arrangements failed to show risk distribution, right? So they took a look at the direct policies. What is their risk distribution? In this case, for medical malpractice, the tax court found the number of unrelated risks, 199 physicians at the relevant exposure unit, was insufficient for the law of large numbers to predict losses. 199 is not really enough. Blue Cross has way more than 199 people they're insuring. If they could only insure 199, they wouldn't really be in that business, right? That'd be kind of the background, if that was the entire pool. And compared to cases like Rent-A-Center with thousands of employees and vehicles and stores where sufficient distribution was found, the captives' expected losses were deemed to be too unstable. That made it not really insurance. There wasn't risk distribution, right? It was going to be super feast or famine. And I have a feeling it's pretty much planned to be feast, where the micro captive just keeps all this money. Okay, deductibility. For premium payments to be deductible as business expenses, they must be really for insurance. So we kind of already talked about that. Whoops, went the wrong direction. So what about risk distribution through the reinsurance pools? Because this is where the argument's going to come. Yeah, we understand that our own, the only one directly with us are there, but we're also buying a reinsurance pool to provide coverage in case somebody in our group gets this. And, we pool that risk with a bunch of other companies, right? So while captives ceded about 30% of their business to pools, right, at common threshold, the arrangement was not a bona fide insurance captive in substance. And this is the problem, right? They're trying to meet the technical rule here by saying, well, we're going to get a bunch of these funds, which again, were essentially a bunch which this attorney had set up. We're all going to get them to take, 30% of their income, pay that as premiums into this reinsurance pool. Okay. The problem was it was designed to have a circular flow of funds. The captives received nearly 100% of what they paid to the pools, 94.98% to 99.59%, went back to them from this, right, under the structure. That suggested a primarily circular flow of funds rather than true risk transfers. Yeah, it was all set up so to redirect things back to you, so that wasn't really risk transfers. The pools were thinly capitalized and contracts included significant deterrence to claims. Retains incomes, exclusion for excessive claims. Let's face it, the whole point of this was not to file a claim with these things. So, they had ways so somebody couldn't get in the reinsurance pool and, and then say, well, I'm just going to take the money from the others. Now, you couldn't do that. And the premiums were questionably determined. Evidence suggests the promoter and the actuary manipulated numbers to allocate 30% to reinsurance. Tiny loss ratios, uniform percentage for all the captives, further indicated these were not being set on a really, risk-adjusted basis for the reinsurance. Rather, indicated non-bona fide arrangements that were just structured to meet that 30% magic number they wanted. So the overall conclusion on deficiencies, since neither direct policies nor reinsurance pools achieved distribution of risk, the premiums payments were not really for insurance and not deductible. Okay. Now, this is the one that was new for the Fifth Circuit. Now the question becomes, because again, the IRS went for penalties here too, whether approval was required before an initial letter recommending penalties or before the notice of deficiency. In a matter of first impression in this, a reported decision by the Fifth Circuit, it held that approval is required before the assessment of the penalty, or if earlier, before the relevant supervisor loses discretion. That typically occurs when the notice of deficiency is issued, right? So, since the supervisory approval was obtained before the issuance of the deficiency notice, the statutory requirement was met. So basically, in the Fifth Circuit, as long as IRS can show that the supervisor approved, gave the required written approval of the, basically the penalty before a notice of deficiency was issued or a similar item was issued, right? In essence, at a point where the supervisor still had discretion, it hadn't been thrown into the greater world and going through the rest of the IRS process, that'll be your test. So it's not just when the first time that the agent mentions they might be assessing a penalty. Reasonable cause and good faith defense. The burden of proof is on the taxpayer. Reliance on professional advice can be a defense. The advisor is independent, competent, conflict-free, and the taxpayer provides all necessary information, relies in good faith. Okay. Number one, this goes back to neonatology. Clark could not be used for reasonable reliance. She was an attorney. She knows a lot about this area, but she was the promoter. Because she is the primary promoter, basically, that is considered to be a conflict of interest that a reasonable person should immediately see, right? In order for her to, basically, the theory is whether or not it actually influences her, which is not really the question, but it's pretty clear that she only gets paid if you get to yes. So that puts an influence on her to answer yes, that this works, this works, this works. That's not necessarily true if you just went to, like, talked about the attorney. I talked about, who had the client bring in that letter from the shelter's attorney saying how wonderful, that attorney's letter, the shelter had the opinion. That's different. He went to that attorney. That attorney was going to get paid regardless of whether he said it works or it doesn't. That's the problem. The promoter does not have that conflict of interest. Remember, a conflict of interest is not just does it influence your decision making, but in essence, if it looks like a conflict, it's a conflict. That is the rule, basically under Circular 230. That is the rule. That's the rule the tax court will apply here. That's basically the rules under all codes of conduct. We're not just going to take your word it didn't influence you. We're going to look at objectively, would a reasonable person have concerns that it could influence you? So can't rely upon the attorney. There was no evidence that they relied on anybody else, right? They had the actuaries, Swift's own accountant, and KPMG for the overall arrangement. Nobody else did they show they gave all the information necessary and got specific advice the arrangement as a whole worked. The actuaries for KPMG and Rosenbach, yes, they were setting premiums, but they never said that the whole arrangement worked. So nobody looked at whether the arrangement could work. And he never asked his own accountant to rule on that, right? Okay. Substantial authority, he argued they relied upon IRS private letter rulings for adequate risk distribution was found for captives with 30% pool premiums. And my suspicion is that that's heavily what was being relied upon in designs of this were those old PLRs. But the court found that PLRs were materially distinguishable because they presupposed a bona fide insurance arrangement, right? Basically, you have to understand a PLR does not rule on facts. It will simply, you will stipulate facts, right? So it presupposed bona fide insurance arrangement, that was the problem, and recognized actuarial techniques. And those factual questions, not the legal questions, PLRs decide legal questions, the factual questions underlying it were the issues in dispute. So because of that, there was no substantial authority. And remember, no reasonable cause, no substantial authority, substantial understatement, your goose is cooked on the penalty. You're done, right? So the Fifth Circuit affirmed the tax court decision upholding the disallowance of premium payment deductions and the 20% actually related penalties. The critical takeaway, courts will look at substance over form. That's really important. If you're going to do a micro captive, you have got to demonstrate real, genuine risk transfer and distribution is non-negotiable. Merely meeting a 30% threshold and not being able to show there was actual risk transfer is not going to work. That was the problem here. That numerical threshold, if that reinsurance had been real reinsurance, not this, out with a bunch of micro captives, all of whom are under common control of the same parties, of the party that's marketing the package. That one just didn't work. It's insufficient. And especially because, if they assure you that money, that 30% you're giving, which, 30%, it's like, wait, a corporation would pay 21% tax? If I'm giving up 30 and I may never see it because that's really what's needed, to cover these super risks that might occur. No, so you almost always going to find that somebody's telling them, wink, wink, you're going to get all that money back. That was a big problem that they actually did get. In the worst case, just under 95% of the money back. In other cases, 99%. So there was just whatever was charged minorly for admin costs was what they didn't get back. Beware of circular premium flows. Check the reinsurance pools. Is it circular? What's happening is people are putting money in this and every year getting paid back what's essentially the same amount. That's a circular flow. How capitalized are they? Realistically, yes, I understand that every year we may not need the 30%. We're going to maybe need it some year. How much money is being retained? If they're sending back 99% of what you put in, that suggests there's not a lot of capitalization there in the pool. And terms that deter claims that just aren't normal, right? I mean, it's become clear that this exists just to, on paper, say, hey, we're reinsuring, but make sure that really you're not doing anything of the sort. And that's kind of what the court found. Everything needs to be arm's length. Premium setting, claims handling must reflect commercial arm's length dealing, right? And that's difficult with common control. You got to be squeaky clean there, and obviously this was not found to be. For practitioners, remember, remind your clients in every marketed tax program, they absolutely will not be able to rely upon the promoter, even if the promoter is otherwise a qualified tax professional. The promoter is otherwise totally competent to provide provide guidance on that issue. If they're promoting the package, that is, the payment arrangement is such that they don't get paid unless you buy the package, you're going to have to look elsewhere for essentially reasonable cause defenses based on reliance on a professional. That professional is off your list of who you can rely upon, or anybody hired by them, okay, in that sense. Ensure there's documentation proving the business purpose, actuarial soundness, and arm's length nature of the activities in any reinsurance arrangement. We need a lot of documentation of those things. And remember, the IRS really does look at this area, so don't consider it something you can just ignore. This has been Current Federal Tax Developments for July the 21st, 2025. Again, we will be returning next week, hopefully with the new developments in there. So we'll talk a little bit about what happens in the coming week. If you have any questions, Ed Zollars, currentfederaltaxdevelopments.com. That's my email address. You can try to submit a question there. Also, if you have any issues coming up, I do tend to look in on the Connect sites for the Arizona Society, New Jersey Society, Idaho Society, Illinois, Minnesota, Washington. So if you're a member of any of those, you can post there. And if I see your question, I may respond to it. But otherwise, hopefully you'll have a good week coming up for taxes. We're heading here toward the end of July. So we're going there heading to August, which is the month Congress takes off, which is always good news. There won't be legislation for that month. So, and a lot of Washington takes off. So we expect a kind of lesser period for guidance in that period. But so we're coming up on that. So we may see a few things kicked out toward the end just before they all disappear. We'll have to see what comes up. But otherwise, we will see you next week for whatever happens in the coming weeks in the area of current federal tax developments.